All right, Mr. Publisky and Mr. Wolf, you're gonna go into a breakout room, Mr. Blankenship, and then we'll recall the case.
Sounds good. Thank you.
All right, I guess we need to handle in-person matter. Mr. Gooden's here on one more. Let me do the Diggs matter or Dibbs or whatever it is. Ypsilanti Township versus Michael Dibbs, 23T 10770 and 771.
Paul Barnett on behalf of the township.
It's the same one for Little One. All right, we're here today for what there is a no. We're here today for what is supposed to be a formal hearing in this matter.
That's correct, Your Honor. There's two tickets. They relate to a vacant lot located at 7114 Hitchingham. On that property, there's a boat on a trailer. There's another trailer truck with rusting propane tanks inside. So we're asking that the court, since there's nobody who has appeared for the ticket, to find a default and enter an order requiring the removal of these vehicles from the lot within 7 days, and requiring that there's some brush, overgrown brush, requiring that to be clear cut, and otherwise brought into compliance with the township ordinance. And if that does not happen within that time frame, to allow the township to enter the property and bring it into compliance, removing the vehicles, cutting the brush, and charging that amount back to the homeowner or property owner.
Granted.
Thank you. I'll prepare that order and submit it.
Thank you. I will sign it upon its submission.
Did I miss anything, Ms. Carconi?
No, thank you both very much.
You're
Okay.
very welcome. Thank you. Have a good day.
You too.
All right, we're going to handle the in-person matter now. Mr. Walter Ford, if you can unmute your device while we get set up for the next matter, please.
Yes, ma'am.
Mr. Ford, you're here in court today. We're trying to figure out why you're here.
I was told to be here for probation violation, I guess they said.
The magistrate set you over from arraignment.
Yes, on I think this was Saturday.
Yeah, do you have your, I think it was Friday, but do you have your case number?
Maybe it's in this text.
Your Honor,
Yes.
I believe he's supposed to be here tomorrow morning at 9.
You're on the wrong day, Mr. Ford.
Okay.
So see you tomorrow morning at 9 a.m.
All right.
And you have to look for your, do you know how to use the chat feature, sir? Because apparently the court's been trying to communicate with you. The recorder's been trying to communicate with you all morning about this.
I'm looking at the chat. I see Arnold Daniel speaking, and then somebody says, "What matter are you here on today?"
That was a direct message.
That was a direct message to you, sir.
Oh, okay. No, I didn't understand that.
All right. Thank you, sir. Have a good day.
You too.
Are they bringing him in? The court will call the case of Ypsilanti Township versus Cal Mulholland, case number 21T00078.
Paul Barnett on behalf of the township.
Is anyone from the PD office representing Mr. Mulholland, please?
I am here, Judge Assistant Public Defender Chinazi Carey Akinruli, on behalf of Mr. Kyle Mulholland.
Thank you. All right, we're here for the sentencing and its violation of probation matter. Have you had an opportunity to review the the recommendation with your client?
We have not, Your Honor. We weren't able to make contact with Mr. Mulholland. I did not know he was in person today. I do apologize. I wanted to put him on the breakout list, but I just figured since I didn't see him that he was not present. If we could have a very brief breakout room with him, I can review the report. I do have it.
All right, we're gonna have to put him back out in the hallway so he can go over the report with his client. His attorney. We can do failure to appears while we await for the return of Mr. Blankenship and his clients. Court will call cases of Ypsilanti Township versus Ahmed Alexander. Case number is 23T00361, 23W001595, B, C, D, and A.
This is Senator Davi Lebo for Mr. Alexander. I do not have any information as to why he is not present today.
He already has a bench warrant in case number 23T00361. That bench warrant is to continue. Defendant has failed to appear in the A, B, and C matter. The subject civil infraction. And in the failure to or disobeying a police officer, warrant to issue. In that case, $5,010%. Ypsilanti Township versus Eric Oliver, case number 22T00860.
Paul Barnett on behalf of the township.
This is Public Defender Dodgy Lebo for Mr. Oliver. I have not been able to have contact with him.
He failed to appear at the last hearing as well.
Move for a bench warrant.
Bench warrant to issue in this case. This is an assaultive matter, $10,000, 10%. Ypsilanti Township versus, State of Michigan versus Corey Warman, case number 21-00212, and Ypsilanti Township, case number 23W001372.
Paul Barnett on behalf of the township.
This is Public Defender Dobby Lebo. I have for Mr. Warmanen. I have not had contact with Mr. Warmanen, however, would request a show cause in these matters due to the nature of the offenses.
As it relates to the township case, that's a possession of drug paraphernalia charge. So I guess I wouldn't object to a show cause, but I'll leave that in your discretion.
Well, that might be the case, but for the fact that he was just arraigned on a bench warrant on June 14th and told to be here today. He failed to appear.
So I'll move for a bench warrant then.
Bench warrant to issue in both of these matters. $2,500, 10% in the drug paraphernalia case. $5,000, 10% in a larceny case. Actually, wait a minute, in a larceny case,
I believe that's just money owed, Your Honor.
it is. So in that case, as a matter of fact, he's already done 79 days on that case. Do you know if there's no, this is a state matter. I'm gonna make that $1,000, 10%. I'm sorry, 1,500, 10%. State of Michigan versus Onaji Neely, case number 16-00704. The state case, the state prosecutor is not here. Onaji Neely failed to appear at the last hearing as also, which was scheduled for a show cause for failure to appear and failure to pay. Could you tell me if Onaji Neely has made any payments? No payments made. Bench warrant to issue. $5,000, 10%. What will we call the case of the Ypsilanti Township versus Anthony Publiski, case number 23T10844.
Paul Barnett on behalf of the township.
Jason Blankenship again on behalf of Mr. Publiski. I've had the opportunity to speak to my client and to Mr. Wolf about the things that we discussed in the breakout session with the court. And before I get to those, they did make something clear to me about the taping off of the line that I just want to make sure the court was aware. The day after the hearing, my client or Mr. Wolf took the tractor and cut off the section of the trail as per the court's recommendations. And then his wife was the one who came out the next day or so afterwards and taped off the area just so all riders would be aware as to where the new turn was. So no one's ever ridden south of that line, and they've been doing everything in their power to accommodate their neighbor. But the two issues that we had wanted to discuss were in terms of frequency in the week. No issue with it not being every day, but as I told the court, coming up in a little bit, they're going to have some folks from Vacation Bible School staying with them, and they'll probably ride, 4 days that week, 5 days that week. It's not going to be a regular occurrence, but agreeing to 2 or 3 days a week, it's a little, it's a little difficult to say, okay, well, when does that reset, that kind of thing. So I just wanted to bring that to the court's attention.
Any response, Mr. Barnett?
I mean, I guess the only thing that jumps out at me is it was sort of, we heard testimony about, I think, 4 riders or something. And now if we're increasing the number of riders, it seems to me that's going to increase the amount of noise. So that could be problematic. I would ask you to follow the parameters that we discussed in chambers, the 3 days a week.
So I have 2 options here, Mr. Blankenship. I can make a finding that it's just unreasonable based on the testimony that I have at this time, or your client can comply with the 2 to 3 days a week that I just indicated I'd be willing to do as compromise.
Well, Your Honor, my client and I are certainly willing to compromise. I guess my concern is,
Those are the 2 options, Mr. Blankenship.
I mean, it's, if Mr. Wolf is willing to abide by 3 days a week, or if he
He
would
doesn't
be,
have to be. He can have me make my decision, and he can make an appeal.
No, we would be willing to, Your Honor, we're willing to abide by 30 days.
All right, thank you.
the other issue that I would bring up is we discussed 8 o'clock. As everyone knows, during the summer months, sunset isn't until I just checked. Sunset isn't until today. 9:15. If he and his family get home from work, and out, we're talking 7 to 8. I'd ask that he be allowed to ride until dusk.
It just sounds like we don't have an agreement. Mr. Barnett, is there anything you'd like to say?
I was comfortable with the parameters that we discussed in chambers, and I would ask you to adopt those.
Well, the reality is that either we have a compromise that comes out of this case, or we don't have a compromise, and I have to make the ruling. That's essentially where we are. That goes to both sides. If they're not willing to compromise, then I have to make a ruling on the initial hearing about whether the usage is unreasonable. So, Mr. Blankenship, I hear you saying that you're not willing to have your client enter into that compromise.
Well, that's not what I'm saying, Your Honor. I'm saying that I heard the discussion from from yourself, Mr. Barnett, and I in chambers. Obviously, I had to speak about that with my client. My client raised the issue of, particularly in the summer months, we have more daylight. I think
I
that,
was aware when I made that decision, when I came up with my agreement for the big.
I
That
mean,
was
if
why I said my initial response was to take this under advisement and continue it until the end of the summer, so I can see whether or not there's an actual issue. The reason I'm willing to do a ruling right now that enters into this compromise is because it ends the entirety of the case and I don't have to, nobody has to wait to hear if I'm gonna make a ruling that the initial testimony was unreasonable. So it's either a compromise right now or I keep it under advisement until the end of the summer. And then at that time, I'll make my ruling. Or this is the, I don't. There,
I hear you, Your Honor. I guess I would just ask Mr. Wolf and Mr. Poblisky if they would, if they want to go with this compromise or want to keep it under advisement. And, you know, simple, you know, it's up to them. I don't live there, so it's up to them.
Your Honor, this is Mr. Wolf. I'm willing to take the compromise. I believe Mr. Poblisky probably is going to have final say, but I'd be willing to take the compromise.
Mr. Poblisky, you're the named defendant. on
Understood.
this, so
Yeah,
ultimately-
if Adam is good with that, then I am as well.
Okay, if they were fine with it, I'm fine with it, Your Honor.
So the parties, the way I see it is that we'll find that this case is resolved with it's a simple resolution, basically, and the court will never make a ruling on it, but we'll just enter an order and the ticket will be dismissed that says that these are the hours in which the people will operate. It will be 2 to 3 times per week. Anytime between 10 a.m. and actually what I'm going to do, Mr. Barnett, is 8:30 p.m.
That's fine.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
And within the confines of the agreed upon trail, however you guys word that, which is very unique to be worded. So I'm not going to get into trying to figure that part out. But the new defined trail. And I understand that the neighbor is not here today, but I am going to say for the record that, you know, the township should keep that into consideration if any complaints are made. That is the time frame that the court is looking at as reasonable, and that's my determination. So any complaint that comes back within that time frame is not going to be deemed unreasonable.
Your
That's
Honor,
just what it is.
this is Mr. Gooden.
Yes, Mr. Good.
I'll put that in my notes in the file for the township.
Okay. All right, thank you. All right, if you, Mr. Barnett and Mr. Blankenship submit an order that will go on this file so we can always be able to look back at it, that would be great.
Understood. Thank you.
And thank you everyone for working this through. I understand it's a very unique situation. And everybody's entitled to use their property. Just trying to figure out what that balance is, and it's not always easy. So thank you for working through it.
Okay.
Thank
Thanks,
you,
Your
Your
Honor.
Honor.
Thank you, Your Honor.
Thank you, Your Honor. Thank you,
You're
Paul.
welcome. The court will recall the case of Ypsilanti Township versus Kyle Mulholland, case number 21T000078.
Paul Barnett on behalf of the township.
Public Defender Chinaza Carey, I can rule, Your Honor. On behalf of Mr. Mulholland, Mr. Mulholland, can you state your name for the record, please?
Kyle Mulholland.
Hello, Mr. Mulholland. You're okay, sir. Thank you.
So, Your Honor, we
All
are,
right.
sorry, go ahead.
No, you can't.
Okay. My notes indicate that we are here for a violation of probation. We were here on, I think, May the 31st. We were supposed to be providing proof to the court of Mr. Mulholland's medication, as well as his discovery group information. He states, I did forward a copy of that prescription to probation. I did it just now. So I'm not sure if Ms. Straub has been able to receive. Did I attach it, Ms. Straub?
Nope.
Oh, I'm so sorry. I'll attach it right now. I have a copy of that. Mr. Mulholland indicates that he signed a release of information from Don Farms for initially Mr. Heaton. I guess I would just need to know from Ms. Straub whether or not she's been able to get that information from them.
I don't have any information regarding his Dawn Farm treatment.
So with that, Your Honor, I think the last time we were here, we did plead to the violation. You said that's correct? Yes, we pled to the violation, and I think we also just informed the court of the relapse that Mr. Mulholland had around the time where he had this positive test. I do not have any information from Community Corrections of any additional positive tests since that particular date. He states that he has been fully involved in the discovery group, and he's been working very hard. Unfortunately, I do not have any proof of that working hard with discovery group to provide to the court today. Our conversation I thought that was something that we would be able to get from the background, but I would just ask if the court would be inclined to give us a brief adjournment. I can send some necessary emails to them to get that information for that proof. I do have the prescription that he gave to me that day we were here the last time. And that's the only thing that I have in my notes that we were supposed to be providing proof of community corrections compliance. I don't have proof either way. And then those other two pieces of information.
He tested positive for fentanyl. I'm kind of confused. There's a prescription for fentanyl?
No, Your Honor. I just have in my notes that we need Suboxone was the medication. It was fentanyl and a benzodiazepine.
Prove that he was actually on Suboxone. Okay.
That is correct, Your Honor.
As to discovery group, why don't we have that? I mean, I adjourned it from May. This is July. I don't quite understand.
Your Honor, I do not know. The only information that we had is that Mr. Mulholland signed over the necessary release of information. He said that was Mr. Heaton was the probation officer at the time, so he was under the impression that information was forwarded to him. But if Ms. Straub does not have it, then it obviously wasn't. I didn't do any additional follow-ups after knowing that he had provided that information to Don Farm.
Sir, you haven't contacted probation in any way, shape, or form since the last hearing. Why is that?
I just have not this past month. I haven't.
But why not? That's my question.
I was just going through what I needed to do with Don's Farm, and I figured that the information would have been able to get the information from Ted Heaton because I signed the release to him.
You're supposed to be reporting to probation every month anyway.
Well, I normally do, but I was thinking that I was in contact because this was something that was supposed to be given to the information Ted Heaton would have, but
Ms. Straub, are you able to see his test results from community corrections?
Yes, so he's been pretty compliant. I mean, he missed a test June 1st. But otherwise he's been testing consistently and he's only positive for the Suboxone prescription.
Ms. Akiri, how long do you need to get this documentation to me? Because right now he's looking at jail time unless I can prove otherwise, and I'm not adjourning it. Again, this is the last adjournment.
I understand, Your Honor. I won't leave the office today until I get that information.
How long will you need?
I think a week is fine.
Well, you'll be in luck, you'll get two.
Okay, thank you, Judge.
Mr. Mulholland,
Yes, Your Honor.
it behooves you to reach out to the probation department, sir, to make sure that they have everything that they're supposed to have by the
Okay, Your
time they
Honor.
come back to you.
Okay.
Sentencing is adjourned to July 19th, 2023 at 11 a.m. in person, sir.
Okay, Your Honor.
Your bond has continued, you to continue testing 5 times per month, okay?
Yes, Your Honor.
I'll see
You
you
said
next
how many
week.
times a month, Judge?
Test 5 times per month.
Okay, Mr. Mulholland, that's a difference from what we were doing last time. So just make sure
No,
that
no,
you,
it's not. It's the same thing. I ordered it last time.
oh, I'm sorry. My notes said, 2 times weekly is what you did. Sorry, I apologize, Your Honor. I thought I wrote monthly. Okay.
Thank you.
Thank
You're all
you.
set, sir. All right, I think that's our docket.
Thank you.
Have a good day, everybody.
See ya. Take care.
Have a good day. Mr. Mulholland, please.